Often, as parents or grandparents plan lifetime gifts or for disposition of property interests at death, they struggle with deciding whether to employ a trust to manage the transferred assets for the benefit of their loved ones. Depending on the kinds of assets being transferred and their values, trusts may be ideal, even essential, arrangements to provide proper management and protection for the beneficiaries. Trusts are flexible and allow someone to precisely define how transferred assets should be managed, by whom, and for how long. A trust is a separate tax-paying entity that may require obtaining a taxpayer identification number from the IRS, preparing and filing trust income tax returns annually, and paying professionals to help with its administration. If the transferor does not intend for a long-term trust arrangement and prefers that the assets be managed by a third party for a short period of time, the costs associated with a trust will not be warranted. For those instances when a trust arrangement is not practical, one option has always been a custodial account or arrangement. Ohio has adopted a version of the Uniform Gifts to Minors Act referred to as the Ohio Transfers to Minors Act. This law allows a transferor to designate a custodian to hold legal title to the property to be transferred to a minor as the beneficial owner. Custodial arrangements for minors may be created by lifetime gifts or by way of gifts upon death. One may even designate a custodian for a minor beneficiary of a retirement plan benefit. While the custodial arrangement is in effect, however, the custodian has complete control of the custodial property, similar to a trustee, with authority and responsibility to manage and invest the property and to decide how to spend or use the custodial property from time to time, for the benefit of the beneficiary. Parents and grandparents were dissatisfied with the prior law's age restriction of 21 for custodial accounts, as they believed situations necessitating property management for young individuals warranted oversight beyond that age. The Ohio legislature addressed this concern by allowing a transferor to provide that a custodial arrangement remain in place until the beneficiary reaches 25. Effective for Ohio custodial arrangements created after April 6, 2017, the transferor may require that the transferred property be subject to the control of the custodian until the beneficiary reaches 25. This change in the law is significant. It now allows some transferors to forego the use of a trust arrangement if they are comfortable with turning over control of the gifted property from the custodian to the beneficiary at age 25 versus 21 under prior law. If you have any questions, please contact Mo Bidar at 216-621-7860.